Hello, welcome back to Let's Talk Title with Emerald Coast Title Services. I'm president of ECTS, Dion Moniz.
And I'm Ashley Bowen, a licensed title agent and director of operations.
All right, so today we have yet another legal update. We have some more revisions to, I guess we're calling it Condo Law 4.0. And so some updates with regards to the milestone inspections and SIRS, and then some updates to the condo rider, right? All right, so we'll first go over the milestone stuff. So in on July 1st of 2025, this year, there's some changes that have gone into effect with regards to the milestones and the SIRS, or Structural Integrity Reserve Studies. So primarily, there's some major ones, but we'll touch on all of them. So they refined what habitable story means, because it applies to any buildings that are 3 or more stories. Well, they kind of refined it and said, well, it's 3 or more habitable stories, which means living space, sleeping space, or cooking space.
So it doesn't include parking garages.
Correct.
Yay.
Right. So if it's a 4-unit dwelling that's 3 stories or less, then they're exempt. So 4 living dwelling units or less, and 3 or less habitable stories exempt. So they clarified that, because I guess there was some confusion there.
And we do have a couple of small condos on Old 98 that are short, small, so that's good for these people.
Absolutely. And that applies for SIRS too. So those specific buildings are exempt from milestone inspections and the SIRS requirements. All right.
So that's a benefit of a small condominium.
Yeah, exactly. So now they've also mandated that the local municipalities have to adopt ordinances requiring these associations to start any Phase 2 repairs within 365 days of that Phase 2 report, which I was kind of surprised it's that long that they have to get started. But
so if they don't pass the Phase 1 report, run the Phase 1 milestone inspection, then they have to have their Phase 2 inspection.
Yep.
And now it's saying that the municipalities, like the city government, is going to change their laws so that whenever a condo doesn't pass its Phase 1 and it has a Phase 2, then I guess they probably will have to deposit that report with someone at the city.
Yeah, well, yes. So they're basically saying, hey, cities, you have to adopt ordinances now, your own laws, that require these associations to begin the repairs that are required under the Phase 2 study within 365 days. So I guess there'll be some penalties in there if there's, for non-compliance. But they're putting some teeth, or making the municipalities put some teeth in to require these associations to get the repairs going within that year time frame.
Okay.
So that was kind of interesting. So the initial deadline, now that's on the milestones. So switching to SIRS now, Structural Integrity Reserve Studies, the deadline on those used to be December 31st of 24. Now they've bumped that a year. So now the initial deadline for everyone to get theirs in is December 31st of 25.
Which a lot of associations that have already got their stuff done and they did it timely feel like this is benefiting those that didn't do what they were supposed to do on time.
Well,
I
yes
wonder
and
why
no,
they did that.
Because if I'm buying a condo, I want this stuff to already be done. Because if there's problems, I want to know that they've already been identified.
For sure.
I had a discussion with a prospective buyer that they were looking at condos, and we were at lunch and talking to the buyer's agent and the buyer, and they were like, well, what happens if these studies aren't done yet? I'm like, well, you're taking the risk that there's some problems that no one knows about, and you're going to be on the hook for those assessments. So I'm glad, or I would be glad if I'm in the market, that these have been done early. So the associations should be happy about that. Their properties now are going to be more marketable because the data is out there versus the unknown. So that's those that don't have them done yet. That's going to affect the buyer's market, in my opinion.
And not only have the reports done and the studies, but also have the repairs being complete.
Yeah.
Because there's so many where they get one assessment and they start the work and then they discover more damage and more money that needs to be spent, and then they special assess again.
Yep.
It just happened to my parents.
Yep.
They went through one assessment and then they just got a second for $30,000.
And that's the problem, is you don't know if the first assessment doesn't pay for it. Yeah. I mean, the exposure's there
Big.
until the repairs are done. So yeah, it's an interesting market for condos these days because of all that. So
now the deadline for the SIRS is extended to December 31st of this year, as opposed to December 31st of last year.
right
Okay.
now, and within the SIRS, they have to specifically identify the mandatory items versus discretionary items. And the threshold for discretionary items, instead of being $10,000, now it's $25,000. So you have the list of structural items that have to be handled. Well, there's some discretionary items they can throw in there as well if the association wants to get them done and wrap them all under that assessment that gets levied. Well, now they have to specifically identify these are the mandatory ones and these are the discretionary ones.
Okay.
But again, the threshold was bumped up now to $25,000 from $10,000. They also now are letting, apparently now the condos have up to 2 years from the milestone to actually do the initial SIRS, which is kind of confusing. Because I don't know why you would want to delay the SIRS. I guess if the milestone comes back negative, you're okay. But if the milestone comes back with something, then you need to be working on that immediately.
Yeah, you should already be funding reserves.
Yeah.
Even new condos have to start funding reserves at the very beginning.
Yeah, so I didn't quite understand that tweak that they made. Maybe they'll go back and take it out.
Probably. And Condo 5.0.
Condo 5.0, exactly.
Next summer, coming soon.
Yeah, exactly. So this is a major one because prior to July 1, the condos associations had to fund everything through assessments, right? So we saw six-figure assessments coming down from some of these condos in Destin. Well, now I think they've realized, and we've talked about this in our podcasts, especially in South Florida, where all the retirees live in condos, they're on fixed income, they can't afford
a $60,000, $80,000 assessment. No, they can't.
No, and so that was, those people were, having to sell or get foreclosed or whatever. So I guess the legislature saw the flaw, and now they're allowing the reserves or the projects to be funded via special assessments, loans, or lines of credit. So they're going back and letting them take loans out to fund those projects that are required under the milestone.
So that's good.
Yeah, excellent. So I'm glad that they improved that. And that's really it for the major ones. They also, the retention period, now these associations have to hold on to the milestone inspection reports for 15 years.
Ooh.
Excuse me. So, yeah. Luckily with cloud storage, you just upload it to the cloud and it's there instead of having boxes sitting around for 15 years. But all right, so those are the major or the significant changes to the milestone inspection requirements and the SIRS requirements. So now we're going to move on to condo rider.
Yes, so they updated the condo rider same day that the new law went into effect. The condo rider came out on June 30th for effective date of July 1st. So now whenever you go into Form Simplicity and you pull the condo rider, this is what it should look like. This is for FAR-BAR. As always, that's our fave.
Use FAR-BAR, right? We don't like CRISP.
The very first change is right at the very front of the condo rider, right up top. There's now a disclosure that says that if the property is a part of a master or other homeowners association, the seller shall complete Rider B, homeowners association. If the property is a part of more than one condo association, seller shall also complete a separate Rider A for each condo association that the condo is a member of. And I love that it says seller shall complete Rider B or seller shall complete an additional Rider A, because it's making it clear that the seller should be filling this thing out. I've always said that.
Yep.
It still doesn't always happen. The seller's the one disclosing all of this information to the buyer. The seller should be filling it out.
Absolutely.
The next change is right below that, and it is all these blank lines where it tells you the contact information for the condo association and the management company. And your title agent loves that it's right there, and we don't have to go search for it.
Yep.
It used to not be on the condo rider. It was always on the homeowners association rider, but now it's on the condo rider, so easy access for the title agent and the buyer to know how to get information that they need.
Absolutely.
And they've also added a line for you to include this the association's website right on the Condo Writer, because in Condo Law 3.0 last year, there was a new law that will go into effect January 1st of 26, stating that all condo associations with 25 or more units must have a website, and it must house all of the official records of the condo association.
Yep.
And so that is where the buyer can obtain the information that they need, or the seller can get it to pull it for the buyer. They did not really make any changes to the association approval or a right of first refusal if the condo association or the members of the association have a first right of refusal. So we don't really have to go over that section. On fees, they did say seller represents that the current dues are this. So again, seller fills this out. My favorite change, though, is going to be in the special assessments, section 3C. When we used to talk about the Condo Writer, I used to say, like, seller beware, this is a scary document.
Right.
I told everybody, don't fill this thing out until you are under contract so that you can fill it out with the most up-to-date information.
Exactly.
Because if you don't fill it out properly, then the seller's on the hook for all of it. It's not like that anymore. Yay!
Yeah.
All the scary
Good
stuff
change.
is gone.
Yes.
It used to say that the seller represents the seller is not aware of any special or other assessments that have been levied by the association or have been an item on the agenda or reported in the minutes within the last 12 months, except as follows. And then there were blank lines for the seller to put in all of those pending assessments. And then it said, if special assessments or levied or pending existed as of the effective date and were not disclosed by the seller will pay them in full at closing. And that was scary. Now that's gone. Now it just says, if the association has levied any special or additional assessments as of the effective date, then either the buyer or the seller will pay them in full at closing. It's not listed right there. There is a section to list anything that the seller knows about, to disclose it, in section 3C, but it's not on the seller to have to, if they left anything out, then they have to pay it in full at closing.
The gotcha language isn't in there.
No, and
Yeah.
I'm so happy it's missing because
Yeah.
it was bad. Because as I mentioned earlier, once the work begins for these structural repairs, a lot of times they're finding more work that needs, and there's more assessments that are coming out,
Yeah.
and it's happening at a rapid speed, and sellers can't hardly keep up with how fast it's happening.
Yeah,
So I
exactly.
was very happy that they removed that. So it is on, the seller still needs to disclose what they know, but it's not going to be detrimental if they don't disclose everything. You still have to, in section 5, it still says that the buyer has either received or will receive all of these official records. But as I said, starting January 1, all of those official records will be found on the association's website.
Exactly.
The seller will have access to that website. It does not say the seller or buyers representatives or sellers representatives. It just says the owner, the seller. So the seller will have to still go get those documents from the website and pull them unless they give their agent access to their portal.
Right.
Now, paragraph 6 of the Condo Writer is new. This is where the buyer can request additional documents that are not a part of the official records up in 5. So the buyer can request minutes and agendas of board meetings for the last 12 months, minutes and agendas of member meetings for the last 12 months, insurance declaration page, or any documents that are in the 9.3s. I can tell you about those in a minute. I personally would, if I were the buyer, I would want all of those. I would want the minutes and the agendas for all the board meetings and the member
I agree
meetings.
completely.
Member meetings are where decisions are made. So like if they have to pass anything and they need the majority of the membership to vote, that happens in a member meeting. Board meetings are pretty much just the day-to-day workings of the association, but there are some decisions that happen in board meetings too, so I would want all of them. The insurance declaration page, 100% need that. If your buyer is getting a loan, because their lender's going to need it, and it is historically a document that gets forgotten about, and the lender will ask about it like the week of closing and say, oh, we don't have the master deck page for the condo insurance, and then we have to postpone closing for a stupid insurance page.
Right.
That could have been requested right up front.
Yes.
So I would say go ahead and request it.
Yep.
And then for the 9.3s, the next box, I would check that too. What it is
Yeah, what's a 9.3 document,
what
actually?
What it is, so in the 9s, the paragraph 9, it talks about the milestone inspections, the SIRS inspections, and then turnover inspections. The 3s are if these things are required to be done but haven't been done yet. And so this 6B, if paragraph 9A3, 9B3, or 9.3B is checked and the document is actually received by the seller before closing, then the buyer wants a copy of it. Well, of course they do.
Yeah, well, sure.
So if they haven't, so I would just always check that too. I would check all boxes in 6B if I were the buyer.
Yeah, exactly. I agree 100%.
So there's that.
Go
The
ahead.
one pretty large change of this is that the buyers now have 7 days to review all of the official records instead of 3 days like they had in the past, because there are so many more records now.
Yeah.
And like the SIRS report is hard to read. They may need to take it to a CPA or an attorney to help them go over it. So they give them 7 days.
Preferably a
review.
CPA. I don't want to review SIRS.
Yes. And then we talked about the milestones, turnovers, or structural integrity reserve studies in a past podcast on the Condo Writer.
Yep.
But again, every condo, unless it's exempt, is going to exempt by being 3 or less habitable stories and 4 or less units. All of them are going to be required to have a milestone inspection and a SIRS inspection. So you can go ahead and say that they're required to be done, and depends on the association if it's been done or not. They mostly should have all been done, except for those few that have waited to the last minute. And then the turnover inspection report, these are only going to be required if the association was turned over after July 1st of 2023. So again, in Destin, the majority of our condos are older than that, and so that will always be a not required for the turnover inspection section. And that's pretty much, that's the big things that changed. I'm happy with the new rider because it doesn't put so much on the seller to know. It gives the buyer a few more days to review the documents. It is clear that the seller needs to be filling this thing out for the buyer. And I like it. For the most part.
I do too. And something else that they left out, which significantly changes the liability under this section 3 with regards to the assessments, is they all used to say if any assessments are levied or pending, and now it just says
Levied.
have been levied.
Yes.
So in our prior classes and podcasts, we'd always preach, all right, seller, you need to go through the last 12 months of minutes, and if there's any hint of an assessment,
You need to
you need to disclose it. And now it only focuses on those assessments that have been levied.
And it defines levied. It says a special or additional assessment shall be deemed levied for purposes of this paragraph on the date when the assessment has been approved.
Yep.
So it will be in the minutes. Remember, meeting minutes.
Yep.
I agree. I think that's great that it's not just pending, it's levied. But if the buyer wants to know what all has happened, then they need to request all the documents in 6B and go through the meeting
That's
minutes.
what I was just going to say. So with regards to pending assessments, it shifts the risk onto buyer.
Yes.
So now buyer really needs to be diligent in reviewing those 12 months of minutes to see whether there's any assessments in the pipeline.
Yeah, so it puts the diligent
Yes.
effort on the buyer as opposed to the seller in this
Yes.
situation.
So it's a shift, it's a burden or a risk shift, which is interesting. It's good,
I think it's good.
but something to be aware of. So
I mean, I do think that the seller should disclose everything that they know because they should know more than a
I agree.
potential buyer
Yes.
would. But the way that the assessments have been getting approved.
Yes.
It's too much. It's too much for any seller to keep up with.
Right. Exactly. So, yeah, big change there. Well, do we have anything else as far as the updates?
No, I think that's it.
Okay. Well, hopefully you enjoyed this legal update. I'm sure we'll have another legal update within a month or two.
Oh, God,
as
I
often
hope
as
not.
they keep changing the laws. But anyway, yes, feel free to check us out on all of our social media channels or ects.com. We'd love to hear your questions, or if you have any ideas for what you'd like to see on a future podcast, so please reach out and let us know. And in the meantime, we'll say see you later. Bye-bye.